What's unfair and
And we're overlooking
prejudicial?
evidence.
What's unfair and prejudicial?
I'm sorry.
What is unfair and prejudicial about me hearing this case?
Oh, there's multiple events, multiple dates, multiple concerns in regards to this matter. I have not been able to secure evidence.
You can't just talk a bunch of crap. You've asked me to recuse myself because it's unfair for me to hear the case, correct?
That is correct. And I can
Okay.
prepare a motion and an
Okay,
affidavit.
hold on a minute. All right. First of all, this is a jury trial, so I'm not the trier of fact. Second of all, what's unfair about me being the judge on the case?
Oh, well.
Why am I biased? Why do you think I'm biased or I can't be objective? Tell me why I should recuse.
Right.
Sir.
All right, Mr. Nunley, your appearance.
Royce Nunley appearing on behalf of the defendant. We'd waive a formal reading and stand mute.
Thank you. I'll enter not guilty plea. All right, we're looking at a pretrial date with Judge Green. That'll be by Zoom on January 3 at 9:30. Have you seen the bond rec and had a chance to discuss that with Mr. Williams?
I've seen it. I have a few comments related to the bond rec. So I saw that what they recommend is like his failure to appear as a reason to ask for a cash bond. However, there wasn't really a willing failure to appear. He's been incarcerated since November of 2019. He was incarcerated. In February of 2020, he was moved to the Michigan Department of Corrections. He was released from prison on December 28th of 2022. Just recently pulled over in.
So a year.
Yeah.
He's been out a year. Yep.
Yep. He was pulled over in Ypsilanti because of like a taillight issue or something, and they told him about the warrant. He had previously found out about it, and he called the court to set up this January 3rd date. Like he told me that the date of the hearing and the time of the hearing, the judge that's assigned, so he was already ready to go. So he's been taking steps to move this thing along and get himself in front of the appropriate judge already. So
all right.
I think he's a good candidate.
Okay.
Thanks.
And he's in good standing with parole.
That is correct. Yep. His parole officer, I think, is the one who told him about the warrant because the parole officer didn't want him to have any hang. He's due to be off parole on Christmas Eve. So in a few days.
Okay. Well, hopefully Merry Christmas early, Mr. Williams.
I appreciate that, sir.
All right. So I'm going to put you on a personal bond. First condition is the obvious one. Stay out of trouble between now and January 3rd. Second condition is be on Zoom at 9:30 on January 3rd, so we can actually have something accomplished on the 3rd. Raise your right hand for me, please. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess that up?
Yes, sir.
Any questions from me or Mr. Nunley before we terminate the meeting?
No, sir.
All right. Good luck on the 3rd. Thank you, Bell. Royce, we'll let you know if we get any more in.
Sounds good. See you.
All right. Good morning, Mr. Phillips.
Good morning.
Counsel, your appearance on the People versus Phillips.
Yes, good morning, Your Honor. Sona Movsisian on behalf of People, PA 3923.
All right, we ready to go?
Yeah.
Ready?
Yes,
Okay.
Judge.
All right, so let's just, because lots of moving targets. My understanding is what we're here to do today is cover both sides 404B motions, correct?
Correct, Judge.
Mr. Phillips?
And I,
Your Honor, I just have a few concerns. I don't even know if we can even proceed today because there's other issues going on in regards to this case with his interference from the complaining.
You're muffled. I'm sorry.
I have COVID because my son got diagnosed with COVID on Saturday.
Okay, just so you know, that doesn't mean you have it. That means you've been exposed.
No,
go ahead.
I don't feel well, but
Go ahead.
But I'll move this closer. So in regards to this case, Your Honor, the defense is unable to proceed in this matter. There's several issues, substantial and procedural defects in this matter that give rise to a dismissal on the January 14th, as well as the other one, 2201-3499 matter from 7/18.
Okay, you keep referring to the January 14th matter. I don't have a January 14th matter.
Oh, it's the extra information that was amended in the complaint for this same case, January 14th.
I only have one file. That file has a range of dates.
Yeah, the 6th
which
date.
was amended. What are the dates now? We've amended the complaint.
we have, Judge.
What's our window? I think it's July something.
It was from July 18th, 2022. For some reason, it's not written correctly, but it should be. And then it just includes July 18th to August 10th and then January 14th because of the request to amend it.
Okay, so
I don't know
there's
why
a
it's written
range
that
from
way.
July 18 to August 10 of 22, and then one day of January 14, 23. It's all one case, all one charge.
It's 2 complaints, 1 case.
It's not 2 complaints. It's an amended complaint to
Mhm.
include July 18 through August 10 and January 14.
Right, 1 complaint into the court, but the amended date is the January 14th.
I'm just clarifying your language. You said that case. There is only one case that's going to trial.
It's 1
It's a
case.
stalking charge. Those incident dates are what the prosecutor's using.
Right, and so
Okay.
I'm referring to January 14th of this year, which will be technically the 6th allegation date in regards to the 23-00743 complaint with the police department, not the complaint in the actual court. However, that's added
Okay,
into
get to
this
your point.
complaint.
You're gonna make a motion to dismiss?
That is correct.
Get to your
However, I'm sorry.
Get to your point.
Okay, so in regards to that January 14th, it is known to the court, it is known to the prosecution that that did not occur. And there is police interference in regards to what's going
Okay,
on. police
okay, your
misconduct,
motion's
and
denied. Your motion's
prosecutorial
denied. That's what
misconduct.
trials are for, Mr.
Okay.
Phillips. I'm not
Okay,
gonna dismiss it because you say it doesn't happen.
I didn't say that.
Motion's denied.
Okay,
What's the next thing we have to get to before we do 404B?
very good. So in regards to that, again, I'm requesting your honor to recuse itself from the court as well as this prosecutor recuse herself from this court for this court case because it's unfair, it's prejudicial.
What's
There
unfair
is
and
pecuniary interest in the
Hold on.
matter,
What's unfair
and
and
we're overlooking
prejudicial?
evidence.
What's unfair and prejudicial?
I'm sorry?
What is unfair and prejudicial about me hearing this case?
Oh, there's multiple events, multiple dates, multiple concerns in regards to this matter. I have
No,
not
wait
been
a
able to
minute, wait a minute,
secure
wait a minute.
evidence.
You can't just talk a bunch of crap. You've asked me to recuse myself because it's unfair for me to hear the case, correct?
That is correct, and I can
Okay.
prepare a motion and an
Okay, hold
affidavit.
on a minute. All right, first of all, this is a jury trial, so I'm not the trier of fact. Second of all, what's unfair about me being the judge on the case?
Oh, well.
Why am I biased? Why do you think I'm biased or I can't be objective? Tell me why I should recuse.
Right, so from start to present date of this matter, where your honor has heard the case, again, there's been procedural and substantial defects in this matter in regards to the arraignment. We can start there. The case started 9/30 of 2022. I was arraigned 2/22 of 22. The actual first trial date was scheduled for 2/7. Therefore, it speaks to exculpatory evidence not being heard, Brady violations, even to date, that has not
Okay,
been
once
addressed.
again, you're rambling. What was wrong with the procedure of the arraignment?
Oh, it was not held, as well as
You've never been
the
arraigned,
4 months. There was 4 months from 9/30 to 2/22.
and that was my fault because I'm biased against you. Is that what you're claiming?
It's not my fault,
Well, it's got nothing to do with my bias or non-bias.
but there's, again, multiple.
Do you understand why you can request a recusal?
I do.
That there's something personally, there's something that I've got an axe to grind. I can't be fair. There's an appearance of impropriety because you know my ex-girlfriend, or I don't know, but there's got to be some reason why I can't be fair and objective. The fact that you don't like the way we do things doesn't fit.
I
The
didn't say
fact that you
that.
want to control every step of the proceedings and I won't let you, and you don't
Yes.
like my rulings, that's not a reason for recusal.
I didn't say
So
that.
unless you can give me something else, I'm going to deny that motion as well.
Well, that's fine, but I didn't say what you said. So other things in regards to the case is Sixth Amendment a violation in regards to preparing the case.
Which once
in
again is not a
regards to
reason for
investigation.
recusal.
There's been interference in regards to
Okay,
that.
move on. I don't have all day. I'm denying your motion to recuse. What's next?
Recuse the prosecutor.
I can't recuse her.
Okay.
She doesn't work
Are you
for me.
going to recuse yourself?
Judge,
Go ahead, explain how you get assigned.
I've actually, I no longer even do these cases. I am only on this case because of how complicated it is. And that essentially giving it to another prosecutor would no longer make sense. And so, no, he could write a request to my supervisor and ask that I be removed from this case. I would have no objection to that. It does not matter to me. I don't have a choice. That's not my choice to make. He can make the request to my supervisors and they will make that decision whether or not I should be removed from this case.
She handles the cases they assign to her.
And she's handled this case poorly due to the information that she received.
According to you. And once again, you don't get to control things. You don't pick your prosecutor, just like you don't get to pick your attorney unless you hire that attorney. Move on. We're going to do the 404B now. Is there anything else before we do that?
We can move on.
All right. Anything? Go ahead.
Yes, I do, Judge. Just based on our last hearing when we were here about certain things for me to follow up on, I do have just things that I want to put on the record and share. So I was going through my file with the police reports. One of my statements, or not my, one of the statements I had in my possession from the police that Ms. Green had written was missing the page 2 in my file. I don't know if it was missing the page 2 in his file. So I have the full statement essentially, just in case. I don't know if what technically was uploaded and I downloaded onto mine is what he received.
Understood.
So that's the first thing. The second thing is there were requests for emails from the police between essentially what emails Ms. Green, the complainant, sent to the police department. Those were actually all included in the initial police report. And so I have another copy of the initial police report, and then separately the emails that were attached as supplements for Mr. Phillips. So I have those as well. And then lastly, I requested any of the supplemental reports that the police have essentially written since the original report, because they often will, essentially anything that they do, they create subs.
Right.
And so after last week, just because of all of the discovery issues that we had, I requested that, and I have the following of it. Essentially, it's a continuation. I believe his ends at page 19. This then starts at page 19 and it goes, so I have the rest of that. So I just wanted to make a record that I'm turning these 4 documents over to the defendant based on our last appearance.
And there's an objection. So in regards to that,
There is no regards to that.
There's a continuing duty to
But you're
disclose
objecting to her giving you
all
that?
these months.
Are you objecting to her giving you that?
I'm objecting to what she stated. I'll review what she has. Doesn't make it true, but I'll review it.
And I would like to actually know, I think he actually has all of these because he forwarded them, and the police department actually told me that he has them. If anything, I didn't have, like, I didn't have the stuff because I hadn't requested it before. So I just wanted to make sure that's very clear in regards to what I had and what I was turning over.
Okay. All right. So I took another opportunity last week to review the pleadings that have been filed on the 404B motions, both plaintiffs or prosecutors and defense. Anything either one of you want to add to your briefs and pleadings? Ms. Wojcicki?
Judge, the only other thing I think that might be relevant, and I don't have the documentation for you, I've been trying to gather it, is it's my understanding that, again, the defendant has essentially filed another PPO against the complainant in Washtenaw County. She is being represented separately for that. That was dismissed again. And it's just to show that continuing pattern of essentially what my motion.
Objection.
What my motion.
You can't object to her argument during a motion.
What my motion addresses, which is this pattern of using certain entities to continue to harass the complainant. There was essentially no foundation for that motion. Again, I don't have the paperwork. I'm trying to get it from the Washtenaw courts, but I do think, just again to add, based on what I had previously stated, and this was maybe less than 2 weeks ago, she notified me that this had happened.
Okay.
And I would just like to add, Your Honor.
I didn't ask you.
Oh,
I didn't ask
okay.
you.
Oh,
is there anything you want to add to your written pleadings?
Absolutely. In regards to this complex complaining witness and prosecutor in regards to this matter, that individual, Ms. Santania Green, has contacted me through various modes, which prompt a request for a PPO, because I have rights and I'm going to protect myself. Okay? So we're not going to do gender-based violence.
Okay, you don't have to defend it.
Okay.
She's just letting you know that that's one of the things that's under 404B she's seeking to use against you at trial.
And I'm letting her
You don't have to
know.
respond to it now because There's the truth or veracity of that is not being decided today.
Yeah,
She's letting you know that's one of the long list of things that she wants to include under 404B. So there's no response necessary to that. My question is, other than what you've submitted on paper as to 404B, both your request and hers, is there anything you'd like to add to your pleadings?
absolutely. I spoke to it. I'll say it again. Ms. Green, the complaining witness, has contacted me through various
I
modes.
don't care.
I do.
Well, it doesn't matter what you care. I don't care. I don't need to hear that. Whether or not you had justification for seeking the PPO isn't even on the table today. The truth or untruth of what Ms. Moisisian said is not important right now. What's important is she's letting you know that she wants to include that under 404B.
Yeah, she's just misrepresenting information that's filed upon the court.
Which, once again, according to you. So I'm going to ask one more time, and then I'm not going to let you talk anymore. Is there anything you want to add to your pleadings other than this Washtenaw County PPO thing?
Yes, the complaining witness also had our son place a AirTag tracking device in my vehicle on 12/15, the day of the parenting time exchange from Livonia Police Department. It was then heard and discovered in the vehicle off the minor's person in my vehicle. I then checked his phone because he unlocked it willingly, no issue.
Let me stop you for a minute.
Go ahead.
Are you telling me that because you're letting her know that that's some of the 404B that you want to talk about on the day of trial?
I'm gonna add it all in. She's gonna hear it all.
Okay, I just want. Sure, we'll do it. Yeah, put it together. Yeah. All right. So she's on notice. I'm on notice. Got it. Anything else as to the motion that's up today? Motions that are up today.
Yes, so in regards to that, that is a direct violation and it's a cause for dismissal, a swift dismissal. Because it's violating me, it's causing terror, and it's 2 or more non-continuous acts as well.
So even if Ms. Green was standing in front of me right now and admitted doing that, that would not be grounds to dismiss this action.
Well, she already lied in regards to the whole entire 6 allegations.
Which,
but, okay.
you heard what I said, and that had nothing to do with the 404B.
Mhm.
So don't talk anymore because I've given you 3 opportunities and you haven't taken them. So I'm ready to rule on the pleadings. I'm denying all of your 404B motions because the proof is exactly what we just went through today. Under 403, and I'm going to read it because I think the whole damn thing applies to this case. Although relevant, and we can question whether or not all this stuff would be, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Everything I'm hearing from you is almost all of those things, and most of what I'm hearing from you is just going to confuse the hell out of everybody. So we're going to talk about July 18 to August 10 and January 14, and that's all we're going to talk about on the day of trial. We're not getting into anything past, anything beyond that. That range of dates in that January 14th date is all we're going to hear about when the jury's in the building, which is when? January 29th? All right, now, are you still seeking a court-appointed attorney? Because my understanding is they're just waiting for you to fill out some paperwork before they can process that.
Who is they? I don't know who they is.
MIDC.
Oh,
My understanding is you didn't want to fill out the paperwork Ms. Patton asked you to fill out.
she never asked me to fill out anything.
I sent it to him and he did not fill it out. And that's what they need.
Your name is Miss Mortsfield, not Miss Patton. Miss Patton never gave me anything.
Well, did Ms. Mortsfield send you something about a court-appointed
Yes, she
attorney?
did.
Did you fill it out?
I did not.
That's why you don't have an attorney. Have a nice day.
I didn't request one.
Goodbye. January 29th, what time is scheduled?
8:30.
8:30. If you're not here at 8:30 on the 29th, I will hold you in contempt and I'll deal with that after the jury trial.
I'll be here at 7:45.
That'll work.
Please ensure that the defendant is not contacting or contracting the prosecutor.
So what are you doing now? What's your main function?
So I'm doing mostly all sexual assault cases, but the focus is on the untested kids. So sexual assaults from like the late 1990s, early 2000s.
Oh my God, it's got to be.
Yes, I love doing that.
Really, it seems like it'd be so frustrating.
It's the most frustrating. It's so frustrating, but it's also so much more, I guess, interesting, and the investigators that I have are amazing because that's all they do. It's like they're a task force, so anything you need, they will do it for you.
Yeah, and they're all on the top of their game.
Exactly, very good officers. Like, so the
I'm glad you're having
trials though are
fun.
very difficult because there's so many evidentiary issues with them.
Yeah.
And then I get mad, and then I get annoyed that I'm doing these cases, and then I go to trial, and then I feel better. And so it's like,
Well, I'm glad you're having fun.
yeah, it's at least I'm learning a lot. Things that I never thought
Good.
I'd do. So yeah. So technically they had tested all of them after a certain point, and then they investigated almost all of them, and now it's just a matter of bringing them forward. We lost like 3 prosecutors that were doing these cases, and now it's just me. And so I essentially, for the last 6 months, was doing all of those trials that they had left. And then now I'm starting to do some of my own, which is nice because I hate taking cases from other people where it's like they've worked on it for like 2-3 years. And then all I do is just go to trial and I know nothing about it, right? The last one I just did last week, I think it was a week and a half ago. It was from pre-COVID, so 2019, but it was a 1998 assault. And so it just, so many delays on different things. Wow. Yeah.
So we've got an attorney, local attorney here. I've been a friend of mine for 30 plus years. I got to ask him if he's still doing this, but just sole practitioner, right? And for a while, no, that's right. And for a while, does a lot of family law. Does criminal too. You probably met him, Murray Duncan.
Yeah.
Yeah. All right. So he does a lot of family law, and he was just like hired gun because a lot of attorneys take divorce cases, but if they're actually going to trial, they don't want to go to trial. So they just turn the file over to Murray at the last minute and say, go try this case. And he told me, he said, I love it. And I got to back up though. Back as a new attorney, I used to cover stuff for Murray Duncan. So he'd call me and say, hey, can you handle a civil pretrial for me in Wayne next Monday? I'm like, sure, Murray, I'll drop off the file. And he'd drop off a folder, and you know what was in it? A copy of the complaint. That was it, right? He's just a pure seat of the pants guy, right? So he's not big on prep.
Yeah.
And back to the divorce trials. And he said, I love it. He said, because if it tanks at trial, it's because they didn't do a good job with the discovery process.
Yeah.
And if I win, it's because I'm such a great trial attorney. It's a win-win for me.
I wish I could think of it that way because I get more bogged down and like I get frustrated that
You're not a seat of the pants.
Yeah, that people didn't do what they need to,
right.
Especially because I'm so particular with how I do things.
Yeah.
But I mean, that does work. So yeah, I don't know. Sometimes it's like, wow, I can't believe we just pulled this off and it wasn't even my case. And it's like, you know, then you can essentially, if you can do that, you can do really anything, right? Mr.
Keith, I'm going to put you on a personal bond. First condition is stay out of trouble. Second condition is show up on Zoom on January 3rd so we can move this file along. Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond?
Yes, sir, I do.
Any questions for myself or Mr. Nunley?
January 3rd on Zoom, or is there there's a personal in-person one I can go to, or how's that work?
If you can't do Zoom, show up at the court. We'll put you on a computer here.
Okay. Understood.
Anything else?
Nothing further.
All right, you can step back. How about Graylin's next, or Regan's next? I'm sorry. Mr. Regains, can you hear me?
Yes, sir, Your Honor.
All right, go ahead, Mr. Nunley.
Royce Nunley appearing on behalf of the defendant. We would waive a formal reading, ask the court to enter a plea of not guilty on his behalf.
All right. Ms. McKeith, you have any questions?
No, sir, I do not.
No, I'm talking to your mom. Your mom's on Zoom with me.
Yeah.
I'm all set, Judge. Thank you very much.
All right. Go ahead. I'm sorry, Mr. Nunley.
Just waive a formal reading and ask the court to enter a plea of not guilty. I noticed there were some old misdemeanor files. We'd waive a formal reading on those also. Same thing, ask the
Okay.
court to plead not guilty.
Yep, did it. All right, so we've got from October 13, 20, we've got 2 misdemeanors, no insurance under the code and open intoxicants in a motor vehicle. We're going to set both of those for a pretrial with Judge Green on January 3rd. And as to the felony count from July 18, 23, set that up with a pre-conference also on January 3rd with Judge Green by Zoom. So let's set all these up at 9:15 in the morning.
Got it.
And the police department is making a suggestion for personal bond. I'm assuming you're not going to talk me out of that, Mr. Nunley.
I am not.
All right. Sir, am I saying your name correctly, Regains?
Yes, you are.
All right. Mr. Regains, I'm going to put you on a personal bond on these 3 files. First condition is you stay out of trouble. Second condition is you're either in court or on Zoom January 3rd at 9:15. You understand that?
Yes, Your Honor.
All right, raise your right hand for me, please. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 on each of these files for a total of $3,000 if you mess up on bond?
Yes, Your Honor.
You can put your hand down, sir. Do you have any questions for Mr. Nunley or myself?
No, I do not.
All right, have a seat. Adrian May. Mr. Nunley.
Royce Nunley on behalf of the defendant, we waive a formal reading, ask the court to enter a plea of not guilty on his behalf.
Done. We're looking at a PCC date, January 3. Let's talk bond.
I ask the court to consider a personal bond. I know that the department has requested a 10,000 or 10% bond. My client has indicated that he's not on parole, that he has no outstanding warrants that he's aware of. He is working full-time at the Bell Tower Hotel in Ann Arbor, lives in Ypsilanti with his mom and his brother. He understands the charges and that they're serious, and he is looking forward to getting this process started and this matter adjudicated and behind it.
Detective, oh, never mind, I found it. Thank you. Mr. May, you live in Ypsi, you work in Ann Arbor, correct?
Yes, Your Honor.
Any reason for you to be in Van Buren Township?
I got arrested for I had a warrant out for my arrest.
You've got a warrant for your arrest where?
It was for here. I didn't know about it until yesterday.
What's the charge?
No, I believe that about these charges, Judge. There's a little confusion when
Are
I
you
was
talking about the case I'm arraigning you on, Mr. May?
Yes.
Okay. Other than that, do you have any reason to be in Van Buren Township?
Oh, no, Your Honor. Sorry.
All right. So I'm going to put you on a personal bond. The first condition is the obvious one, you stay out of trouble. Second one, you stay out of Van Buren Township unless it's to drive through Van Buren Township to get to the 34th District Court on January 3rd. Your court
Yes, Your
date's
Honor.
going to be at 9:15 in the morning by Zoom. If you can't get on Zoom, then you can show up at the court. Other than that, stay out of Van Buren Township. You understand that?
Understand, Your Honor.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $5,000 if you violate bond?
Yes, Your Honor.
Do you have any questions for myself or Mr. Nunley?
No, I do not.
All right, step back. Jonathan, I'm gonna pronounce it Geyer.
Yes, sir.
Did I say that right?
Yes, sir.
Mr. Nunley.
Royce Nunley, on behalf of the defendant, we waive a formal reading, ask the court to enter plea of not guilty.
Done. Pretrial date is January 3rd with Judge Green by Zoom. Let's talk bond.
Again, I would ask the court to consider a personal bond. This matter arrives from some incident with the defendant's mother. He does live with his mother. I've indicated to him that there's going to be a no contact that's put into place, and I explained to him how serious this court takes its no contact orders. He understands that. He indicated that he does have somewhere where he can go once released from there. He is currently on probation out of Westland. He was wrapping up his probation. He said he's only got like a few more dates of a community service that he had to fulfill for the city of Westland. And then he was going to be eligible for an early discharge from probation. However, I do believe that he is sincere in wanting to come to court. He had a lot to say about defenses to the charge, which I told him, wasn't the appropriate forum but when he gets to court the next time, whatever attorney there would be more than happy to help him get it adjudicated sooner. So I don't think he's a flight risk. I don't think he's a danger to the community. I think he understands that he's not going to be able to talk to his mom. I told him he could probably go back with a civil standby, but then that was it. And he seems to understand that and willing to cooperate.
What's the charge out of Westland, if you know, Mr. Nunley?
I do. So there was it was some sort of,
Like an assault?
yeah, it was some sort of assaultive crime. I don't know the details of it.
Okay.
I can fill you in, Your Honor.
I'm sorry?
I can fill you in if you want more
I just want to know if
information.
mom was involved in that case.
No, sir.
All right. Anything else, Mr. Nunley?
Nothing further, Judge. Thanks.
All right. Mr. Gar, I'm going to give you a chance to do this on a personal bond. First condition is stay out of trouble. Second condition is stay away from 9276 Parkwood unless you go back with a civil standby to pick up some personal property. Third condition, no contact with mom, no phone calls, no letters, no social media contact. You run into her at Taco Bell, you're eating at Burger King. I know it's coming up on Christmas, but that doesn't change my bond condition. Understood?
Understood.
You
Loud
can
and
either
clear.
spend Christmas on the street without mom, or you can try to see mom and spend Christmas in jail.
Understood. Loud and clear.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $5,000 if you violate bond?
I swear and fully understand you, Your Honor.
Do you have any questions from myself or Mr. Nunley before we terminate the meeting?
I do not, sir.
All right. Sergeant? Are you still Sergeant Mike?
No, I'm still a detective. I'm still
All
being.
right, well, Detective Long, Merry Christmas. Stay safe.
You too, Your Honor.
Thank
Do
you.
you have a court date? What was the time on that court date for him?
January 3rd. I think I did it at 9:15. Let me check.
Okay,
9:45. 9:45.
very good, thank
Mr.
you.
Nunley, can you contact me by phone at your convenience, unrelated to arraignments?
Yep, I have a consult in my office now. I could call you about an hour though.
Perfect, thanks.
Yeah.
Thank you, Merry Christmas.
Merry Christmas.
Same to you.
Well, It's a good mood today. I'll go all Frank PR bonds.
With I'll be Mr. Barber.
Good morning. Have you filed an appearance?
Your Honor, I did. I looked online that it wasn't entered, so I brought another one.
Yeah, let's get you in the system. Thanks. All right, counsel, looks like we got a plea. Tell me about it.
Your Honor, today we'll be pleading to amend the charge of operating visibly impaired. The original charge of the high vacancy would be dismissed.
All right. Mr. Barber, have you discussed your rights and options with counsel?
Yes, sir.
Understood those?
Yes, sir.
All right. And you understand the possible penalty for the added charge?
Yes, sir.
Understanding all of that, are you pleading guilty freely and voluntarily today to the added charge?
Yes, sir.
Counsel, would you voir dire to get me the facts I'm looking for?
Sure, Mr. Barber, back on December 9th of 2023, were you driving a vehicle vehicle here in City Romulus on South Wayne Road and Grant Road.
Yes,
And were you pulled over by the police?
yes,
And prior to being pulled over, had you been drinking?
yes, sir.
What had you been drinking?
Bourbon,
Okay, you remember how much?
it was quite a bit, almost a fifth.
Okay, and would you disagree that your blood alcohol content at that point was above 0.08?
I would not disagree.
I'm satisfied if you are. Okay,
Thank you.
Mr. Barber, I'll accept your plea to the added charge. I'll dismiss the original.
Thank you.
You're welcome. Next step is I'm going to send you downstairs to make an appointment with the probation department to come back for a pre-sentence interview.
Yes, sir.
They'll also schedule a sentencing. You can have some input on that one, counsel. Based on that interview, they're going to put together, they being probation, will put together a report and recommendation for sentencing. You'll come back at the sentencing date. You fellows will have a chance to look at that report. I'll have it looked at the report, and the three of us will have a conversation about that report and anything else you want me to hear about. And then I'm going to determine what the sentence is.
Yes, sir.
Understood?
Sounds good.
In the
Thank you.
meantime, I'm going to put you on a personal bond unless you would try to talk me out of it.
That's
No,
fine.
personal bond will work. First condition is the obvious one, stay out of trouble. Second condition is almost as obvious, cooperate with probation so we can get you through that process and get you back to sentencing for me and counsel and yourself to have a conversation. Third condition, do not purchase, possess, or consume any mood altering substance. That includes alcohol
Yes,
in the
sir.
meantime.
Right.
Any questions?
No, sir.
Raise your right hand. Do you, sir, swear or affirm and acknowledge the debt payable in the court amount of $1,000 if you mess that up?
Yes, sir, I do.
Any questions?
No, yeah.
All right, fellas, downstairs.
So they'll
Have a
give us
great
the sentencing date downstairs?
Yep.
Okay,
All right, thank you, Judge.
You're welcome. Yeah,
That one's just a dismissal.
got it.
That David sent it.
Yep. Ahmad Nasrallah? Not here? Can't object to a dismissal then.
See if I can get Hadley or Bowman in here.
Yep, thank you. And I thought that Miss Tiroli was coming up with our one and only show cause, but
I'll give her a ring. You have a name on that? Tomas?
Rathbone,
Thank you.
which is fun to say. Trying to figure out why my date stamp looks funny. It's because it's February 1 space 2024 instead of February 01.
Oh, yeah, it's not over.
No, it's just one. I mean, I can do it all one. Oh, 71 is about right.
All right, thanks. Rathbone is speaking to, Rich, and I don't know who this is on Zoom. That happening that I know of.
Let's find out.
Probably wrong. Zoom
Yeah,
number.
let's find out.
Don't have it.
All right, that was Barbara we just did. You didn't do an alphabetic one today, did you?
No, 'cause it's so small.
Yep.
Rachel? Unmute yourself.
Took care of that.
No, not you.
Yeah, I'm looking for you.
They didn't give me any paper. What's your last name? Okay, thank you.
All,
Mr. Bowden is here for the 2 hours.
Your call. Good morning, Mr. Bowich.
Good morning, Your Honor.
Which one would you like to start with?
I only have one, Mr. Osceola.
Did he say it right?
Yeah.
Come on up.
We practiced.
All right.
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with the defendant. Sir, could you tell the judge your name for the record, please?
I am Kevin Casiolik.
Thank you.
Thank you, sir. Your Honor, today's the date and time set for arraignment in this matter. We waive formal readings and view. We've also had a chance to pre-try this case. We do have an executed plea agreement subject to court approval. In that agreement, Mr. Casiolik would be pleading responsible to the charge of impeding traffic.
Good.
With the understanding the original charge of driving an off-road vehicle on the road would be dismissed.
And is that the way you want to take care of this?
Yes, Your Honor.
All right. Was there any conversation about fines and cost amount?
$350 was what the prosecutor.
You've agreed to that amount as well?
Yes, Your Honor.
All right. Can you pay that today or do you need a payment plan?
I think I can pay that today.
All right. Go downstairs. The same place you pay it is where you pay part of it and set up a payment plan for the rest if you have to.
Okay.
All right. Got all that? Original case dismissed. Any questions?
Nope.
You're all set. Do you mind doing a similar case for Mr. McLean, who Mr. Hadley spoke to?
Oh, no. Not
Mr. McLean, come on up. You're all set. Go downstairs and listen for your name at the cashier.
I think this is a companion case, Your Honor.
Okay, all right. Same deal for you. You're gonna plead to impeding traffic. You've agreed to pay fines and costs of $350. Right. Is it all right if Mr. Bowditch?
Okay.
Is it all right if Mr. Bowditch stands in for Mr. Hadley, the attorney?
Yes.
Okay, and you've agreed to pay $350 as well?
Yes, sir.
Okay, I'll accept your plea. I'll dismiss both the charges that were issued to you on that date.
And I'll pay for his. I just gotta go to the bank.
Okay, go down and make sure he doesn't do something else. Well, you can come back today and take care of both of them?
I would have to go to my bank first. And it'd probably be maybe a day or two.
Go down there and make arrangements for,
The young man is with, I believe, his grandmother.
Yeah.
Make sure that she knows she's the one that's gonna pay. So make sure that she's comfortable.
Yeah,
no problem at
I've
all.
known them for a long time. They know my girl since she was 1.
No problem at all with us giving you a couple days. Just set that up.
Okay, let me
Okay.
talk to him real quick.
Yeah,
All right,
no
I
problem at
gotta
all.
raise my hand, see.
No,
You're all set.
Okay, all right, thank you.
You're all set. Thank you.
All right, so I just, the outright dismissal was on the B ticket, the reduction was on the A ticket. Jamie, did you check with the guy sitting in the back?
He's getting notice for adjournment. Ma'am?
Come on, Ms. Roach. Good morning, counsel. Your appearance for Ms. Welch, please.
Good morning, Your Honor. Attorney Josh Hadley, on behalf of the defendant, Ms. Okayla Welch, who's standing to my right.
Good morning, Your Honor.
Good morning.
Akila Welch.
What do we got?
Your Honor, we are going to be availing ourselves of the people's plea offer. We're going to be pleading guilty to the reduced charge of disorderly person under the delayed sentencing statute, MCL 771.1. We're at the period of 12 months. If there's no new criminal offenses, the matter would be taken off. With the caveat that there will be no contact with her neighbors, Teresa and Alvin Strong, that they're not to go onto that property of Teresa and Alvin Strong, which is at 15807 Birch.
Yep.
And there's an agreement, there'll be no playing of music from the car or house that's audible to people outside before 9 a.m.
Okay, so I've got 2 files for Ms. Welch. I've got a trespass and I've got a threats. Do we care which one gets dismissed and which one gets reduced?
My understanding would be the threats is dismissed, trespass is reduced to disorder.
Okay, that works.
But I don't, Mr. Greco didn't have a, but yes.
That'll work for me.
Disorder.
All right, Ms. Welch. All right, go ahead.
We'll ask, we'll cover that when you're done.
Ms. Welch, did you discuss your rights and options with Mr. Hadley?
Yes,
And do you understand those rights and options?
yes,
You understand that the possible penalty for the trespassing charge is up to $500 fines plus court costs and up to 93 days in jail.
yes, I understand now.
Understanding all of these things, are you pleading guilty, freely and no? Are you pleading no contest, freely and voluntarily to the charge of disorderly person.
Okay. To disorder.
Yes.
Yep.
And you understand when you say no contest, you're literally saying, Judge, I'm not fighting that charge.
I'm not gonna fight the charge. I just wanna
Okay.
be able to go around kids.
Okay.
Okay.
Understanding all of that, where do I get my facts?
Offense date of, I want to say it was August.
November 30th.
November 30th. Miss Welch, on November 30th.
No. Just no contest plea. So that means I'm not going to get the facts from her.
And I mean, we'll rely on the police report first. We'll stipulate the.
Which would work great.
If we had one.
If I had one. And the appearance ticket doesn't have anything in the remarks section. So if you can get your hands on one.
I've got one. Give me just one second. My apologies.
No problem.
771.1. I didn't think we were doing an NC. Mr. Greco, I just spoke with, though, he has no issue with it.
Okay.
Correct. So, basis the police report, we would, Ms. Welch enters a plea of no contest that on November 30th, 2023, while in the city of Romulus, she did act in a way that caused a disturbance of peace.
And you're satisfied with the factual basis as provided?
I am, Your Honor.
I will accept the plea. All right, ma'am. You're welcome, ma'am. What should I consider before I sentence?
She's on a fixed income, Your Honor. One of her biggest concerns is that she's still gonna have the ability to be around her granddaughters. This isn't a criminally minded person. This was an argument between neighbors that had been friends. Relationship had kind of soured over the recent dates. We just ask that you come in on the lower end of the fines when fashioning your judgment today, considering her limited ability to pay.
Thank you. Ma'am, anything you want to add to that?
No, just my concern when my granddaughter comes over my home, the complainant and her husband, they'll come out and start challenging, provoking me. I can't even walk in the home. This has been going on for some time, but I understand I was wrong. I am involved with youth, children.
Okay.
They're not. I need to protect my character so I can give back to the future.
Yep.
And build. This is a mistake. I did not know by sending that picture would be a criminal act, but I knew that would make them leave me alone.
Okay.
Thank
All right.
you.
All right, so what we're gonna do is I'm gonna go along with the delayed sentence for 12 months. That means stay out of trouble, no new criminal offenses, okay? No more neighbor problems. I'm ordering, as per the agreement, I'm ordering you to stay off the neighbor's property and that any music you have on before 9 a.m. is quiet enough so that it can't be heard outside the home, your home.
Okay, but our house is closed. I just turn it off.
Buy some cheap earbuds. That way you can hear and nobody else can.
Okay.
All right? Anything else?
No.
No, thank
All
you.
right.
Thank you, Your Honor.
You're welcome.
Okay, thank you.
All right, fines and costs, $180.
Okay.
You need a payment plan, ma'am?
Yes, Your Honor.
I get a check on the 3rd, I can pay.
Go downstairs to the front counter and you can settle a payment plan with them. If you want to
Okay,
make, break it up into a couple payments or just pay it all after the 3rd, whatever you want to do.
Okay, thank you.
You're welcome.
Thank you.
You're very
Good luck.
welcome. Thank you, Your Honor.
You're welcome. Oh, yeah, she got to go to probation because we got terms on the delay.
Okay.
So start at probation.
Sit her down, check in.
Yep. All right, Mr. Puda, come on up with your appearance for Joshua Lucas. How'd I do?
Pretty good.
How do you say it?
Lucas, like there's no T.
Okay.
Good morning, Your Honor. Julian Food on behalf of the defendant, Joshua Lucas. Your Honor, we have reached a plea agreement here with the prosecutor. They've agreed to dismiss the original charge, OWI. My client's going to be pleading guilty to an added count of operating while visibly impaired.
Okay. Have you discussed with counsel your rights and options?
Yes, sir.
You understand those?
Yes.
You understand the possible penalty for the added charge?
Yes.
Are you pleading guilty to the added charge today freely and voluntarily?
Yes.
Mr. Puda, would you board here to get the facts I need?
Yes, Your Honor. I'd like to direct your attention back to October 29th, 2023. Had you been operating a motor vehicle at or near Inkster and North Line Road in the city of Romulus?
Yes.
And had you consumed alcohol prior to operating the motor vehicle?
Yes.
And you later came into contact with the police?
Yep.
And they did a blood draw?
At the hospital, yes.
And the blood results, do you stipulate that they were 0.13?
Yes.
Do you agree that the consumption of the alcohol impaired your ability to operate the motor vehicle?
Yes.
Your Honor, I'm satisfied.
I am too. I'll accept the plea to the added charge, dismiss the original. All right, Mr. Lucas, I'm going to put you on a personal bond. I'm going to send you downstairs to deal with our probation department. They're going to schedule to have you come back for an interview with a probation officer. They'll also schedule a sentencing date. Mr. Puda, you can walk down and hopefully pick that sentencing date. Based on that interview, probation will put together a report and a recommendation for sentencing. You fellows will get a look at it when you come back for sentencing. I'll look at it, we'll talk about it, and then at that point, I'm going to decide what the sentence term should be. Understood?
Understood.
Your personal bond is first condition, the obvious one, stay out of trouble. Second condition, cooperate with probation so we can move this towards sentencing. Third condition, do not purchase, possess, or consume any mood-altering substance that includes alcohol and/or marijuana, unless you got a doctor's prescription. Understood?
Understood.
Any questions?
Nope.
Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond?
Yes.
We're all set. Go on
Thank you,
downstairs.
Your Honor.
Have a good day, gentlemen. No, that wasn't part of the deal. So just stay off the property.
Here it's no contact, you stay off the neighbor's property. Yeah, you even said the name. I did hear you say.
Oh, see, I thought that was no contest.
Oh,
I thought that was a no contest.
no, no contact.
Oh, I'll have to explain. That's why Josh was so freaking confused.
Yeah.
Yeah, then it continued, continue the no contact. All right, I'm gonna go grab my water. Okay. Okay. 4 tips for eating out food. Go at lunchtime because lunches are cheaper than dinners. Of course, it's too small. Yeah, that's kind of obvious. Do not order juice. If juice is expensive and sugary, it just makes you more thirsty. Order water. Okay, yeah, I didn't need it. I didn't need anybody to tell me that one. Don't order an appetizer. Oh, in other words, don't order more stuff if you're trying to save money. Ask for it to go container. Yeah, that was like 30 seconds of my time wasted.
That was,
Those are my 4 frugal tips for eating out on a budget.
that's like not even, it should be go at happy hour.
It was all obvious.
Yeah, exactly.
Yeah, go happy hour and get nothing
Appetizer.
but appetizers, yeah.
Yeah, because you can get full off of those, because if you want a smaller portion and you're talking about going at lunch, you go at happy hour and get the
Yeah.
appetizers. Cause like my sister, where we went last night, we went to a beer Keller.
I've heard that, where's that at?
It's on Allen and Goddard, it's a German restaurant. I've talked about it before.
Yeah, that's why I've heard it.
Yeah, and we went there last night, and it's steak bites. And
Okay,
it's
yeah.
on the appetizer, even though it's $15, but it's like all just big chunks
Yeah,
of
that's it, Rusty
steak.
Crow, it's a huge platter.
Yeah, and it's got, she likes onions, and it's got onions and peppers and everything, and then comes a piece of garlic bread.
Yeah.
It's plenty, but I mean,
Good for meat eaters too.
yeah. So. So the other Verona cases are Belleville cases, they're not Romulus, but I'm giving you the information so that they can do the records check.
Yeah. So Cheyenne found some online ASL classes.
Oh, really?
And she's thinking about taking them. She sent it out to Susie and I said, are you guys interested? So we were at her house for dinner last night. I said, why do you want to do ASL? She said, I've always wanted to do ASL, and I'd like to teach the kids ASL. I'm like, I'm willing to do it, to help you reinforce it with kids, because obviously they'll learn it quicker if everybody's interacting with it that way.
Exactly.
So I sent her a follow-up today. I'm like, so is this a schedule of classes, or can I just take a session whenever I've got time to take a session? Well, we'll see what happens there.
That's kind of a neat idea.
Yeah, I think so. That's
I
from
remember
Oklahoma.
Mindy's-
How she found it, Oklahoma State University.
And online,
Yeah.
Mindy's daughter did that. She went high school, she did ASL, and then I think when she got to college, she dropped it, right?
Yeah, she didn't get certified.
Right, she should have kept going, because that's something that is hard to find for court.
Paula did it.
Yeah.
Yeah, it is. I think it is tough for us to find somebody today. So.
Mhm.
And it'd just be kind of cool if you could yell at your granddaughter without saying anything.
Yeah.
Seriously, I think it's kind of cool to be able to communicate in a way that, like a second language.
Yeah.
If you can call out. Now, let me tell you the story about Susie and Myers. She was in Myers, and she's walking down this aisle, and she can hear this interaction going down this aisle. A woman in German telling her daughter, "You better behave." And it's going all the way down the aisle. Mom's chastising this little girl. You got to start paying attention. Blah 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 blah. So they get to the end caps, and as they get to the end cap, they're coming this way. Susie's going this way, and she leans down in the little girl's face, and in German says, "You have to listen to your mother." And Susie said the little girl, guys, got it. Oh, so big because it's like, what do you mean? Somebody else knows this special secret language that we have at home?
That's funny. That's like,
I said that probably had more of an impact than mom lecturing all the way down.
exactly. Shirley Spearman,
Yeah.
she's African, and she speaks Afrikaans. And she was
I
talking
didn't know
about.
she was in Africa.
Yeah, and she's talking about how she goes, and there's only like a third of the people that can speak it.
Yeah.
And she was at the airport, and her and her mom were like talking about some guy, and he turned around and talked to them in Afrikaans.
Yeah, I think it would be
so
dangerous
funny.
though. Yeah, it would be dangerous because you forget that there might be somebody else out there. Yeah, when I was at the Safari Club thing in Dallas, that's one thing I realized how much I miss that accent, because it's a really cool accent. Like from that area. No, the South African and that region of Africa where the Afrikaans is spoken. It's a pretty cool accent. If you hear it somewhere and you don't know it, you're like, that's not quite German. Is it Dutch?
Oh,
But
really?
if you've been there, it's like, oh no, that's Afrikaans. And of course, there's a lot of people at the show from Africa trying to promote their business. Matter of fact, we had lunch with a couple. We just like a food court, and then all these
big table, so you find a seat wherever you can, and there was a couple at a huge table, just two of them, so we sat down and started talking to them.
They both had pretty heavy accents.
In this courtroom showdown, the defendant tries to convince the judge that the case is unfair and repeatedly demands that the judge recuse himself. However, when the judge asks for specific evidence of bias, the defendant struggles to provide a clear answer. Instead, he continues making broad claims about procedural mistakes and unfair treatment. Judge Oakley remains calm but firm throughout the hearing. He explains that simply disagreeing with the court's decisions or being unhappy with previous rulings is not a legal reason to remove a judge from a case. The judge repeatedly gives the defendant opportunities to explain his position, but the arguments become increasingly repetitive and unfocused. As the hearing continues, the defendant also asks for the prosecutor to be removed. Once again, the judge explains that the defendant cannot choose who prosecutes the case, and that such decisions are made by the prosecutor's office, not by the court. One of the most memorable moments comes when Judge Oakley tells the defendant that he does not control the courtroom or the legal process. The judge makes it clear that the trial must stay focused on the actual evidence and the charges, rather than unrelated accusations and personal grievances. In the end, every motion to dismiss the case or remove the judge is denied. The judge schedules the trial to move forward and reminds the defendant to follow all court orders and appear on time. This hearing serves as a powerful example of how judges separate legal arguments from unsupported claims while maintaining control of the courtroom.